Oh, certainly, yeah.
It has to establish what the objective meaning to the reader is. And we say that when all the material is considered, it doesn't include asylum and does include immigration in its narrow sense. That's the heart of the case. So, short title, page 5. All right. Long title, or preamble, is an act to make provision law and to repeal other retained EU law relating to immigration, to confer power to modify retained direct EU legislation relating to social security coordination, and for connected purposes. Now, pausing there, plainly an act making provision for the repeal of asylum would not be making provision to end rights to free movement of persons. So we're not in that part of the long title. A live question on the preamble or the long title is what is meant by other retained EU law relating to immigration. We say, when you consider all the material, it is actually crystal clear that the reference to other retained EU law relating to immigration means immigration in the narrow sense and not asylum. And then there's a reference to social security coordination and a reference to connected purposes. So far so good. We then go into part 1. The relevant provision on which the Secretary of State depends and which Lord Justice Underhill construed is paragraph 6 of Schedule 1 to the Act, that is in part 1. So we are dealing with a statute, we are dealing with a provision in part 1. The description of part 1 under the heading is measures relating to ending free movement. No reference to asylum. On the face of it, according to the title, the whole of part 1 relates to measures relating to the ending of free movement. Then we come to section 1, which introduces, as your lordships will see, schedule 1. So the heading to section 1 is repeal of the main retained EU law relating to free movement, etc. Now, when we look at the detail of the argument, on the Secretary of State's case, the word etc. is having to do a huge amount of heavy lifting. It's the word etc. is the only way in terms of these headings, to a description of the provisions that we're looking at as covering asylum. And at the end of the day, it's going to be, to my submission, is that the objective meaning of the statute would not give the weight to the word etc. the meaning which it's crucial for the Secretary of State to give it. And when we look at the explanatory notes, there's a perfectly straightforward explanation of why there's an etc. governing free movement. Is to deal with other retained rights such as Chen and Zambano and rights of residence that do not stem from the Free Movement Directive. And then the provision, then section 1 states, Schedule 1 makes provision to A, end rights of free movement of persons under retained EU law, including by repealing the main provisions of retained EU law relating to free movement. So pausing there, nothing in little a that brings in asylum. And then B, end other EU-derived rights, your other retained EU law relating to immigration. So, given that I can establish and do establish that there is a common a distinction between immigration and asylum seen on the face of many legislative schemes, I think is probably as far as I need to go, the question arises, if you stop at 1b, what is the natural meaning, or what is the objective meaning to be given to the reference to immigration? And we say, considering the totality of the material which this court has to consider, immigration there means simply the narrow meaning of immigration described by Lord Justice Underhill. So stop there, and we have got nothing on the face of it to indicate an objective meaning that extends to repealing the provisions relating to asylum. We go into Schedule 1. Your Lordships will find that at page 12 of this bundle. Schedule 1 repeats, Schedule 1, the heading to Schedule 1 repeats the formulation that we have just seen over Section 1, unsurprisingly, as Section 1 introduces Schedule 1. And I repeat the comment about etc. On the face of it, we're dealing with a schedule which, according to its title, is repealing maintained EU law relating to free movement, and then there is the reference to etc. I'll see what the explanation for that is in due course. Then if you look at the substantive provisions of Schedule 1, all of them, but for the words which this court has to construe, unambiguously relate to free movement. So that Part 1 is, of the schedule is dealing with EU-derived domestic legislation. And your Lordships can see without me reading what paragraph 1 says. And there are various other provisions which are designed to end the existence of free movement rights. Part 2 is retained EU legislation. It omits Article 1 of the Workers' Regulation. That's a pure free movement provision. And Articles 2 to 10 are modified, but again are dealing with free movement. And then paragraph 5, you get the favour of paragraph 5 from 5.1b, Annex 1 of the Swiss Free Movement Agreement. Ceases to be available, recognised and available in domestic law, and the Swiss Free Movement Agreement is defined in paragraph 5.2. And then we go into the provision which we actually need to construe. I'll just read the whole of it. Any other EU-derived rights, powers, liabilities, obligations, restrictions, remedies and procedures cease to be recognised and available in domestic law so far as A, they are inconsistent with or otherwise capable of affecting the interpretation, application and or operation of any provision made by or under the Immigration Acts included as amended by this Act. And there's a definition of what are the Immigration Acts elsewhere in the statute. And then I don't think I need read to...
So can I just ask, is there a definition of the Immigration Acts in the Act?
So yes, if your Lordships go back into the it's section 4 of the Act.
Which page is that?
So page 7 of the bundle.
Yes, thank you.
Secretary of State's case, ultimately accepted by Lord Justice Underhill, was that because asylum, the grant or refusal of asylum affects leave to enter, then an immigration rule dealing with leave to enter in an asylum context might be inconsistent with or capable of affecting the interpretation of the Immigration Acts as defined in the provisions referred to in Section 4 and Section 4 itself of this Act. Our substantive case on paragraph 6 is that the reference to immigration in 6.1b is in context when one is searching for the objective meaning to be ascribed to the statute, a reference to immigration in the narrow sense envisaged by Lord Justice Underhill. It's a reference back to section 1b, at page 5 of the bundle, under the heading Measures Relating to Ending Free Movement, and in context plainly relates to either free movement itself or something closely connected with free movement, and we'll see what the explanatory notes say about it in a moment. So if I'm right so far, then the position is that the whole of Part 1 of the schedule relates to free movement. The whole of Part 2 of the schedule relates to free movement. The fallout words of 6.1b relate to immigration in the narrow sense, stroke free movement. And the one exception are the very wide words on the face of it, the literal meaning of the words, I'll come back to that, in 6.1a. No other indication at all of an intention to repeal a whole corpus of asylum rights, the content of which I'll come to in a moment. So the question is, what approach does the court take to arriving at the objective meaning of the reference in 6.1a to something being inconsistent with any provision of the Immigration Acts? The short answer, we say, is that you read 6.1a in the light of the provision introducing it, namely Section 1. You ask yourself, does 6.1a on the Secretary of State's construction relate to ending of free movement? Answer, no, on the Secretary of State's construction, or at least it isn't limited to that. Is it consistent with Section 1b ending other EU-derived rights relating to immigration, when that reference to something relating to immigration is read in context. At the moment, I've just been looking at the headings to the statute, various provisions of the statute. And the answer we submit is no. Objectively, this whole set of provisions is designed to end free movement rights. And so 6.1 is subject to a limitation, but the rights in question relate to immigration. Could be drafted any other EU-derived rights, etc., relating to immigration cease to be recognised and available in domestic law insofar as A or B. If that is not correct, then the result is, on Lord Justice Underhill's own approach, the accidental removal of a corpus of asylum law without anyone having thought about it at all. That, I think, is the case I have to meet. So that's my I think probably second heading on the list, the run through of the main provisions of the Act. The next question, or the next heading on my list, is there a potential difference in various legislative schemes between concepts of immigration and asylum, which should be taken into account when considering the drafting of the Act. If your Lordships have Mr. Lord Justice Underhill's judgment at 352,
Sorry, bear with me one moment, if you would.
352 is page 314 of the bundle, Efron.
314.
Yep.
314 in the key documents, not the... Mr. Drabble, do you have the page number in the main hearing bundle?
I think it's 314.
No, it's 575.
Oh, sorry. Then I'm going to make that mistake again because I've removed it for my own purposes. I thought I got it out of the main bundle, but I obviously haven't. Someone can shout when we come to the judgment provisions. I think it's only the judgment. No, would think it's only the judgment.
352.
352 on the hard copy.
But paragraph 352.
Paragraph 352. Thank you. Sorry to hold you up.
Sorry about that.
It's my fault.
I hope we're now at 352 anyway. And if I can just invite your Lordship to read 352, but essentially it is setting out the case which I repeat today. And while we have the judgment, a place to find the long list of the Immigration Acts is paragraph 349 of Lord Justice Underhill's judgment.
And you don't challenge the accuracy of that list?
No, not at all, no.
We don't have to trawl our way back.
No, no, you don't.
Rather oblique definition to which you referred us a minute ago of Immigration Acts.
No, I mean, the only relevance of Section 4 is that it's putting into the list
Yes.
this statute. I mean, your Lordship will have gathered, there's no dispute on our side that say the provisions of the Immigration Act relating to leave to enter are a provision in the list of Immigration Acts that are set out in Lord Justice Underhill's judgment and are brought into the statute. The question is, how do you treat the relationship between the two limbs of paragraph 6 and section 1, given the fact that section 1, on its face, the face of the title, is relating simply to free movement, and there is a perfectly straightforward and, in our submission, correct construction of section 1, which is limited to free movement of immigration in the narrow sense. What do you then do when you come to the schedule, almost all of which is unambiguously concerned with free movement, apart from the opening words of 6A? Now, our case, which I think, I hope, if I can then take your Lordships to paragraphs 5 and 6 of our case, which I hope is at page 382. And 383. And your Lordship will see we say in paragraph 5, towards the foot of 382, immigration and asylum are distinct concepts in EU law which are subject to separate legal frameworks. EU immigration law is concerned only with free movement of rights of EU nationals and their family members as set out in the Citizens Directive. EU immigration law is not concerned with the rights of third country nationals, save insofar as they have derived rights of free movement of residents due to their relationship with an EU member state. Entry of residents of third country nationals who are not refugees and who do not have rights derived from free movement of EU law, a matter for individual member states. And then by contrast, EU asylum law is a separate and self-contained body of law, the EU Common Asylum System, CES. The purpose of a common asylum policy, of a common EU policy on asylum, reflected in the recitals to the main asylum directives, is to establish an area of freedom, justice and security and justice open to those who, forced by circumstances, legitimately seek protection in the community. And then there's a reference to the first phase of CEAS set out in the recitals to the Procedure Directive. So can we then go to the Procedures Directive, which is the piece of EU law which contains the requirement for connection with a safe third country before you can be removed to that safe third country, which is at the heart of our case. But on the way, we pick up the recitals. So if your Lordships will look at page 4109 of the bundle. we should be in Directive 2005/85/EC, otherwise known as the Procedures Directive. And recitals 1, 2, 3, 4, and 5 set out the EU legal framework within which the Procedures Directive is made. Read it all, but for example, recital 1 states whereas 1, a common policy on asylum, including a common European asylum system, is a constituent part of the European Union's objective of establishing progressively an area of freedom, security and justice open to those who, forced by circumstances, legitimately seek protection in the community. And then that is amplified in 3, 4 and 5. So you have a body of law described in these recitals which relates to asylum and is clearly distinct from the Free Movement Directive, the Citizens Directive, with which we say this statute is certainly primarily, and we say almost exclusively, concerned. And so to repeat, Secretary of State's case is that this whole corpus of law described in the policies set out in the recitals has been repealed without anyone lending their mind to it. See the conclusions on that issue of Lord Justice Underhill, to which I'll come back. Then we have at page 4112 a series of general provisions. Article 1 describes the purpose of the directive. Article 2b is important because of a case called GVG, a Supreme Court case which proceeded on the basis that the Procedures Directive was part of retained law even after the enactment of the statute with which we are concerned, and I'll come to that in a moment. There's something of an issue below about whether or not the comments of Lord Stevens, who gave the judgment in GVG, observing, recording the Secretary of State's acceptance that the Procedures Directive as retained EU law was part of the ratio. It plainly was part of the ratio, because when we come to it, do as shortly as I can, but the phrase that was key in GVG is in the definition of an application for asylum, which, as your lordships will see, means an application made by a third country national or stateless person which can be understood as a request for international protection. And the words "can be understood" were relied on by Lord Stevens after the commencement of this statute to say that the reasoning of the Court of Appeal in GVG could not stand. So it's part of the ratio, but it's unargued, and I can't say there's any binding judgment because of the complete lack of argument on the issue. But
the point about the continuity, the point about retained EU law wasn't taken. The Secretary of State, it wasn't argued. The Secretary of State was asked, do you accept that the Procedures Directive is retained EU law? The answer is yes, he does accept it. But it's not argued. I mean, no one was contending that it wasn't retained EU law. And your lordship may or may not have picked up, and certainly can pick up at your leisure, if I can put it like that in an earlier case of Robinson, before the commencement of our statute, the Secretary of State submitted that the position in relation to the Procedure Directive would not change on the commencement of ICSA. So there's to Lord Stevens. So Lord Stevens knew about ICSA, thought that it didn't mean that they ceased to be retained EU law, but there was no argument. Now, and then if we go on Article 7,
page 4114, provides a right to remain in the member state pending the examination of the application. So that's the substantive right that's in play in GVG, is also relevant here, because you cannot disapply that right to remain in the member state pending the application or pending the examination of the application, except in accordance with the provisions made in Articles 23 onwards. We'll just go to page 4120. Procedures at first instance, and then Article 23 describes the examination procedure. Article 25 describes inadmissible applications. And 25(2) provides that member states may consider an application for asylum as inadmissible pursuant to this article if, and then there are various factors set out, but they include concept of the safe third country, which is further described in Article 27. And that's the heart, that's 27(2)(a), which is the provision which we say renders the scheme for removal to Rwanda unlawful if the Procedures Directive is part of retained EU law. So 27(2) states the application of the safe third country concept shall be subject to rules laid down in national legislation, including A, rules requiring a connection between the person seeking asylum and the third country concerned, on the basis of which it would be reasonable for that person to go to that country. And the Secretary of State accepts that if that is still part of domestic law, the scheme, the Rwandan scheme, falls, because it doesn't require a connection. In fact, there will almost never be a connection. Now, as I say, the Secretary of State's case is that the whole of that corpus of law, the qualifications, including the Qualifications Directive, are simply swept aside by virtue of the opening words of paragraph 6, Schedule 1. Nowhere else in the ICSA statute is there any reference to asylum. So that's the construction issue which the court has to determine. Now, if we then go on to other material that demonstrates the existence in various legislative schemes of separate concepts of immigration and asylum, I invite your lordships to look first of all at paragraph 11 of our printed case.
Sorry, paragraph 11.
Paragraph 11. It's a page of our case, ASM case, page 384 of the bundle. And this is in a piece of Brexit-related legislation, namely the Immigration, Nationality and Asylum (EU) exit close brackets regulations 2019. And the structure of the regulations we state in the case dealt with revocations related to immigration and nationality and revocations related to asylum in two separate parts. And we say that reflects the distinction that we are after. And if the court will look at page 3887 of the bundle, we have the two schedules that we've referred to in our case. Part 1 is indeed headed Revocations Related to Immigration and Nationality. and then your lordship can run an eye down the provisions which are brought into play. And then separately...
It could be said that that reflects a particular context of EU law where asylum belongs to the common framework on justice and free movement belongs to the single market.
Yes, well, I'm totally willing to accept that. I mean, that just brings you back to the question of construction of paragraph 6 of Schedule 1, read in the context of the introductory remarks I've made about the preamble, the headings, and section 1.
Yes, so your argument isn't that there's a general convention in statutory drafting in the UK that immigration and asylum are distinct topics.
No, that's not necessary.
In the context of EU law, there's a clear distinction drawn.
Yes. We're left, I accept that. I mean,
you say the subject matter of ICSA is...
The subject matter of ICSA is pretty well exactly the same as the subject matter of the 2019 regulations. And can I just take the point just one stage further? If your lordships go back to 3887...
Sorry, page?
3887, we're back into Schedule...
Yes.
Part 1, sorry. Revocation of retained EU legislation, Part 1, revocations related to immigration and nationality. Your lordship will see in small typeface that the same line as Schedule 1, reference to regulations 47 and 54. Which are, unsurprisingly, the regulations that introduce, in the case of regulation 47...
So sorry, which page are you on?
3887.
Sorry, thank you.
What has found its way into the bundle is the full text of Part 1 and Part 2 of the schedule. They are introduced in very short terms by the two provisions referred to at the top of 3887 on the right-hand side of the page, regulations 47 and 54.
I'm sorry, I don't see it.
Print, yeah.
Robert?
Yep.
Sorry, I can work it off.
Right.
It's in very tiny print.
Yes, right at the top of the page.
It's in very tiny print, right at the top of the page.
Yes, the top right-hand corner of
But
the
there is a sharp and quite important point, actually.
Yes.
Sorry, just as I understand, is that indicating the regulations which give effect to the schedule?
Yes.
Right.
Yeah, there's the regulations which give effect to the schedule. And if I can just... Your lordships can no doubt go at your leisure, or we can supply hard copies if your lordships want us to. But regulation 47 is actually quite instructive to this construction exercise. And if I can just read it.
Sorry, it's not in the bundle?
It's not in the bundle, and as I say, we can supply it. But it's not of such length that your lordship will be troubled by it. Can I just read it? 47, revocation of retained direct EU legislation relating to immigration and nationality. So the phrase in the heading in regulation 47 is EU legislation relating to immigration, which is exactly the phrase that falls to be construed in section 1 and paragraph 6b, and the query what you do about 6a in that context. And the regulation itself just says Part 1 of Schedule 1 has effect. Now, as I say, we can provide hard copies of that single liner if it's helpful, but so it's not just, to go back to Lord Reed's question, it's not just that in EU law there is a well-trodden distinction between provisions relating to free movement
and provisions relating to asylum, as explained in the recitals to the Procedures Directive that we've seen. There is also, in Brexit-related legislation, admittedly subordinate legislation, a reference to the concept of retained EU direct legislation relating to immigration.
Yes. So you say when legislation is concerned with retained EU law, it draws a distinction between retained EU law relating to immigration on the one hand and relating to asylum
Yes.
on the other hand.
Well, certainly in this example, it does. Question is viewed objectively. What is the meaning to be ascribed to the concept of relating to immigration in Section 1? And we say it's the narrow concept. Because, of course, Reg 47 sits alongside Reg 54, which introduces the provisions relating to asylum, as your lordships can see from Part 2 of the regulations. That's 3889. Headed, revocations relating to asylum. Now, we're going on through the material with an eye on the time, that we introduced in the Court of Appeal, and I think the Divisional Court, the table of long titles that we've already seen Lord Justice Underhill referring to. And it's at page 2356 of the bundle. And your lordships can see them. It's already been pointed out that the Immigration Act 1971, the short title, refers similarly to the Immigration Act 71. But lordships will see that there are many of the short titles that refer to Asylum and Immigration Acts. And a lot of the long titles. For example, the 1999 Act, an act to make provision about immigration and asylum. The 2002 Act, an act to make provision about nationality, immigration and asylum. 2006 Act, your lordships have the point. Now, the Lord Justice Underhill points out it's not universal.
What is the point that you extract from the table?
The point is that this, when you are looking at our statute, you are looking for an indication of what the subject matter of Section 1 and Paragraph 6 is. You start with the short title, which doesn't refer to asylum. You go next to the long title, which doesn't refer to asylum, despite the fact it frequently does. You then go on, as I've already said, to the headings, to the individual provisions, and your lordship has seen the heading to Part 1, which is simply a provision relating to free movement, I think.
But what propositions do you draw from the table?
I draw a proposition from the table that it is possible to draw a distinction between references to asylum and references to immigration, which are at least an indication of the objective meaning to be assigned to the provisions that we are falling to be construed.
Thank you.
Now, is that a convenient point?
That will have to be, I think.
Yes. Well, thank you, Mr. Drabble. We'll resume at 2 o'clock.
Indeed. in EU law by the 2018 Act. Details are set out under the Schedule 1, under the Schedule 1 part of these notes. And your Lordships will find that at page 8109, which describes Part 1, paragraph 60 to 62, Part 2, and paragraph 63 to 65, and then paragraphs 66 to 68 are dealing with Part 3, which is the part of the schedule which is in play for our purposes. And the opening words of 68 summarize the contentious words of paragraph 6 and give as an example the sort of rights that the draftsman of the note envisaged will be affected by by paragraph 6. As for example, the residence rights that are derived from Articles 20 and 21 of the TFEU, rights of citizenship and free movement, will be retained EU law, and unless they are disapplied, will provide a right to reside in the UK for certain groups. For example, CHEN carers who are primary carers of an EU citizen child who is in the UK and is self-sufficient. However, the rights derived from Articles 20 and 21 would continue to apply in non-immigration context. So, on the face of it, an answer to the question that's posed by the reference to other rights, come to Lord Justice Underhill's judgment in a moment, is answered by the fact you have the Free Movement Directive, the principal directive that is being got rid of, if I can put it like that, and you have a series of other residence rights, Zambrano and Chen and Texera, where the rights are derived from the treaty itself, and are in that sense connected with immigration status or free movement. That is the explanation given in the notes that can be read across into the word other and into the etc. And then if you go to paragraph...
Sorry, why doesn't paragraph 68 cover our case? Aren't the rights under the procedure directive directly effective rights that would be saved other than for that paragraph?
They are directly effective rights that will be saved other than for that paragraph. The question is, what is the scope of the paragraph? And my answer to that goes back to section 1. You read paragraph 6 together with section 1. You read section 1 in the overall context of the long title and the heading, and you are dealing with immigration in a narrow sense, and you are not dealing with asylum. The contraindication that the Secretary of State always relied on is the word other that appear in the title and the etc. And it just doesn't bear that sort of weight. I mean, the idea that the whole corpus of asylum law is dealt with by the reference to etc. in the headings.
Right. I mean, the words at the end of the first sentence of paragraph 68, capable of affecting the interpretation, application, or operation of immigration legislation or functions.
Yes, well, that's the wording of the paragraph. I accept that.
Is it not right that that actually is referring to the English law concepts of immigration legislation and functions? Because it's talking about affecting the interpretation of that legislation. So it doesn't necessarily mean the English law immigration legislation.
Yes, I think I accept that in that sentence of paragraph 68.
Right, which takes us then back to what does immigration mean in English law.
Well, it does. With respect, it takes us back to the meaning. To go back to the statute. Yeah. Let me spell out precisely what my case is. Go back to the statute. Page 5 of the new bundle. Lordship has my point on the long title of this statute. You have my point about the heading of Part 1, which includes paragraph 6. The heading is measures relating to free movement.
Certainly, I followed all those submissions. I thought you were showing us the explanatory notes
as
a guide to the purpose of this legislation.
Well, can I just... Well, if your lordships have those points, then the fallout of that submission is that one construes the words relating to immigration in section 1b as meaning immigration in Lord Justice Underhill's narrow sense. You then come to paragraph 6 of Schedule 1, paraphrased in paragraph 68 of the notes, as your lordship has just been pointing out to me.
Yes.
Are the wide words in paragraph 6 to be construed as reflecting a wide meaning of immigration or a meaning consistent with the purpose of Part 1 of the Act? And the purpose of Part 1 of the Act is to end free movement rights, as is apparent from all the titles, as your lordship has. So, and then the next, and in my respectful submission, decisive issue was, if you ask the rhetorical question, was there an intention to disapply the corpus of asylum law contained in the Procedures Directive and the Qualifications Directive? The answer is no, because we have a list of the directives that it was contemplated would be affected by paragraph 6, contained in paragraph 69 of the explanatory notes, which are at page 8111. And, I mean, it's a negative. There is no reference to anything other than free movement directives, unsurprisingly.
But it says it's a non-exhaustive list.
Yes, there are about 3 points on which the Secretary of State's case rests. The first is the use of the word etc. And in the heading to section 1, but not actually in the heading to part 1. The second is the reference to other rights in the long title and elsewhere. And the third is the use of the word except, and the third is the heading to the list in paragraph 69, which is that it's a non-exhaustive list. Now, the Secretary of State's case has to be that objectively one should construe this act as removing directly applicable rights contained in the Procedures Directive and the Qualifications Directive, i.e. the whole corpus of asylum law, because of the use of the word other, etc., and non-exhaustive. Now, in my submission, if one is looking for an objective meaning, the section 1 read together with part 3 of schedule 1, and in particular paragraph 6, that is not an objective meaning that should be given to these provisions. the context simply indicates that you're dealing with free movement and connected rights and not with asylum. Now, as I say, I can't avoid the fact that it does say non-exhaustive list, and it does use the word etc., and it does use the word other. But it just is not a credible construction of the statute as a whole, that by a sidewind, the whole corpus of asylum law is taken out on that basis.
Can I ask Mr. Drabble, the procedures directive we saw was made in 2005. Was it ever implemented in? I mean, directives are supposed to be implemented in national legislation.
I anticipate the answer is it will be contained. Some of the provisions will be contained in the immigration rules. I mean, there's a paragraph in Law, Justice and Nichols' judgment which I have to deal with. I mean, it's quite an important paragraph. Effectively proceeding on the basis that there might not have been any perceived inconsistency between the implementing rules and the underlying directly effective rights contained in the directive. I'm not setting out to prove that's wrong. No. What I do say is that the result of the construction exercise that your Lordship should be carrying out is to ascertain the objective meaning of words of Section 1 read together with Part 3 of Schedule 1. If those words, and put it another way, the submission is that those words should not be construed as evincing a parliamentary intention to remove the corpus of asylum law on the basis of these drafting indications given by other, etc., and non-exhaustive list. And on the non-exhaustive list topic, if your Lordship will go to...
I mean, just on that, of course, it won't remove asylum law as a whole, because there is an English law of asylum which remains.
Yes, indeed.
Including by cross-reference to the Refugee Convention, which
is... Indeed. I mean, I may not get time to really develop this, but part of our case is that if you're looking for the objective meaning of these words of repeal, you look at the rights which which the Secretary of State contends are being removed. And he says, that it is intended to remove important rights sounding in international law, as your Lordship just says. Because the right to have the connection with a safe country requirement is a requirement in EU law governing the exercise of obligations that arise as a matter of international law. I'm not saying that the safe country connection does, because I lost that case.
Yes, you lost that. It hasn't been revived yet, so it's not a...
That's for another day.
International law under the Refugee Convention that there has to be the strong connection.
But the fact is that the Secretary of State's case is that important, directly effective rights sounding in the international law field and providing for a right of access to the UK courts in connection with asylum claims are being removed by a sidewind. And in my submission, one should hesitate long and hard before giving these words, other, non-exhaustive, and etc., a meaning which has that effect.
I mean, one might think that it's debatable whether it is removal by a sidewind. I mean, if one construes the language of paragraph 6 in accordance with its natural meaning, and we've looked at the first sentence of paragraph 68 of the explanatory notes, if the object is simply to remove from the influence of EU law from UK law governing immigration in the wider sense, then it's not by a sidewind.
Well, with respect, if the Secretary, I could well imagine the Secretary of State at the time of the making of this statute
thinking, I want freedom to legislate domestically about free movement, hence section 1. I want freedom to legislate domestically about asylum, hence I'm going to refer to asylum. That will make perfect sense, but they didn't do that. The fact is that there was no perceived thought about whether or not to influence the category of directly effective rights that relate to the corpus of body called the deal with asylum. Had there been, the statute would have said so. And what's more, the list of directives contained at page 8111, paragraph 69 of the explanatory notes, would have included the Procedures Directive and the Qualifications Directive. All of that demonstrates that the Secretary of State was concerned to remove rights relating to freedom of movement and Chen and Teixeira and Zambrano, etc., and was not concerned to remove the directly effective underpinning of the transposing immigration rules and other legislation, to pick up my Lord Reid's point. So in that sense, it is a side wind. And if your lordship, I mean, probably is almost my next stop, and I'm getting short on time, but I mean, if your lordship then go to Lord Justice Underhill's judgment with the side wind point in mind, if your lordships will find sorry, being slow.
Paragraph 340 at page 3.
Yeah, there's a passage which sorry, I had it a moment ago. Yeah, it's a passage, it's at page 578 through to 579 of the judgment, Lord Justice Underhill's judgment. And I hope I've got the right page.
Which paragraph?
Sorry, the passage starts at 360 and finishes at 366. And the building blocks are, in the judgment, first two sentences of 360, clear from the long title, as well as the language and structure of its provisions, that the main purpose is to end the right to free movement and to repeal legislation related to it. And I accept that that is a purpose which has nothing to do with asylum. Pausing there, that's our main construction point, to go on to see whether the use of the other concepts in the legislation like other. And then he says, section 1(1)(b) says in terms that Schedule 1 makes provision to end other EU rights, EU-derived rights, repeal other retained EU law related to immigration. Other must mean other than related to free movement. Well, we actually know from the explanatory notes what rights the writer of the notes had in mind, which are rights directly derived from the treaty, i.e. Zambrano, Chen, Teixeira, and so on. There's no reason at all to construe the reference as other as bringing in the whole corpus of asylum law, and it's inherently unlikely. And then he goes on to say, his first sentence of 361, the question then is whether the phrase relating to immigration defines that secondary purpose in a way which excludes EU-derived rights relating to asylum. I do not believe that this is clear. Now, I've struggled to understand why it is that he's looking for something as a clear intention to exclude asylum. The objective question arising from the authorities on statutory construction is what is the objective meaning to be ascribed to Section 1 and Part 3 of Schedule 1. That objective meaning is simply an intention to remove free movement and narrow immigration rights. There's no hint of an intention to remove asylum rights or any language which, apart from the contested words at the beginning of paragraph 6, have that effect. And if your Lordship then go on through the judgment, (364), I turn to the extraneous materials relied on by Mr. Drabble. I accept that the parliamentary materials referred to strongly suggest that the government, as promoter of what became ICSCA, did not, at the time that the bill was going through, have any specific intention that EU-derived rights affected by paragraph 6.1 would include rights of asylum seekers. If it did, it's hard to think that the responsible Home Office officials would not have referred to it in the explanatory notes and the government's response to the relevant committee reports in the House of Lords. And your Lordship has in our case the various references to the committee reports which talk exclusively in terms of removing rights relating to free movement, not a hint of anything else. That is consistent with the Secretary of State's stance in G and G, which is one of the things I will come to in the remaining 5 minutes I think I've got left. That's given me, and then 365, that has given me some pause. But it does not follow from the fact that the promoters of a statute have not foreseen all the particular consequences of its provisions, that such consequences must be treated as falling outside its purpose so as to justify departing from their otherwise clear meaning. Now, plainly there is an issue between myself and Lord Justice Underhill about whether there is an otherwise clear meaning. If there's another criticism other than the ones I've just made about Lord Justice Underhill's judgment, it is that it proceeds by divorcing paragraph 6 of Schedule 1 from the scope of the schedule established by Section 1 and the title to Section 1. Because if you establish the scope of the schedule by realising that the whole part relates to free movements, what the title says, and you realise that the words in 1b relating to immigration refer to immigration in the narrow sense, then you approach paragraph 6 on the basis that it is not objectively to be construed as removing rights other than those that relate to immigration in the narrow sense. The Free Movement Directive, 10, Texera, Zampano. There is simply no basis for going any further than that. And then Lord Justice Underhill says in paragraph 366, that it doesn't seem that the government thought about it. I'm paraphrasing rather rapidly.
Of course, at the end of the day, the issue isn't what the government may or may not have intended, but what the meaning is of what Parliament enacted.
Absolutely. There's a mistake which may not matter, that he's looking for an intention by the government, which isn't actually the question established by the authorities we cited in our case.
I don't know if he is. I think he's saying if there's a clear meaning, the fact that the government didn't realise precisely what they were
saying that, and I have
is neither here nor there.
I have to deal with the clear meaning point.
Yes, you've explained it. You say paragraph 6 has to be construed by the limitations of Section 1.
Exactly. There's a scope to the whole of the schedule established by Section 1, and that in turn feeds back into the references I've already made to the title and the headings and so on. Yep. Yes. I have to accept that if there's a crystal clear meaning, which you just can't duck, to a provision like paragraph 6, then you're stuck with it. But there isn't, because all the authorities stress that you construe in the context. You construe in the context of the whole of the statute. So my submission is that Lord Justice Underhill, with respect, is aiming at the wrong target. He's looking at, first of all, what the government intended, but secondly, more importantly, at whether or not there was objectively a perceived inconsistency between the domestic transposing provisions and the directly effective rights. But that can't, with respect, bear scrutiny. The question is, objectively, are the words of Parliament to be construed as removing the constraints imposed by directly effective legislation, such as the Procedures Directive? And the answer is, no, they're not. It doesn't matter that there was a project to change them. Just didn't think about it. And the fact that there was no need to think about it is almost my point.
But I mean, the nub of your criticism of Lord Justice Underhill is you don't accept that there was a clear meaning contrary to your view.
Yes.
I mean, the rest of his comments are merely supportive around that argument. I mean,
Yes.
the fundamental difference is he says, look at these provisions, look at paragraph 6, look at section 1, there's a clear meaning. And you're saying, no, there isn't, because you've got to look at the wider context as you have done.
Yes, I would accept that.
Yeah.
Yeah.
Gerald, one quite frequently comes across incorporation of schedules by very brief references
Yes.
in the main act, in
Yes.
this case by section 1. And quite often the language is so brief and so general in the authorising section that you have to go to the schedule to see precisely what...
And it feeds back into interpreting the...
If you apply that to the use of the word immigration in section 1b, you think, what do you mean by immigration? And you go to Schedule 6, paragraph 6, and the reference to the Immigration Acts, which is the bit of Schedule 1 which is implementing section 1b, and then you go and look and see what those are, you get into an area, it might be said against you, you get into an area of Underhill-like clarity.
Well, I obviously don't accept that. But that's. I've probably given the reasons why already, but let me repeat them.
I think I'm just raising a new point with you, which is because this way of doing things, this sort of statutory shorthand, is now so common. It used not to be, I think, fair to say, that you have to get over the hump, don't you, of finding that this sort of shorthand is, generally speaking, elucidated by the schedule to which it refers, or uncertainties in it are elucidated by the schedule to which it refers. Not the other way around, because you're seeking to say that Schedule 6 is rigidly controlled by Section 1.
I'll go so far. I mean, I've given this some thought. I mean, when I first started thinking about this case, I obviously went off to the authorities to see whether there was authority on the scope of a schedule being controlled by the empowering provision. If that's not quite the right word, but you'll just know what I mean. There isn't. I mean, you read the schedule on the basis of what it said. I accept that. But you still have the unavoidable truth, which is that the schedule is contained in Part 1. We know what the purpose of Part 1 is, because the heading says so. We know that there's a meaning to be given to the word immigration in 1b, which is the narrow meaning, because Lord Justice Underhill says so, and I support it for all the reasons I've given. And we know that all the other provisions in the schedule are concerned with free movement, strictly speaking. And so the question then is, what is the objective meaning to be given to the opening words of paragraph 6? And for danger of repeating myself, for all the reasons I've given, the answer is the one we're advancing.
Now, that probably is the end of my time. Can I just take your lordships to G, just to show that it's the ratio? It'll take me 2 minutes, and then I'll sit down.
I think you can take it, the cases on statutory interpretation, which you would have otherwise referred to, are familiar to the court.
Yes, this is Lord Stevens in G.
But we'll look at G.
Yes, this is Lord Stevens. Actually,
Yes, I know it is. And you were going to, initially in your presentation,
I certainly was.
You were going to go more widely, but I'm just reassuring you that those cases are familiar.
Perhaps I could just give your lordship the actual passages.
Yeah, okay.
Passage in PRCBC, the citizenship rights case, is at paragraphs 28 to 31 at page 7001. The passages in PACCAR are paragraphs 40 to 42, page 7015. The reference to paragraph 10 of Bloomsbury in the case, which is at page 5301. The reference to the Hanover case, 4218 to 4219.
Sorry, 4218
to 4219.
Yeah.
And there's a reference on explanatory notes to NAS, which is at page 6906 to 6908. And it's paragraphs 4 to 6. Now, the only point, just to repeat about those, familiar to, I know to your lordship, to my cost, is that you look at the explanatory notes not just if there's an ambiguity, but in order to see whether there is an ambiguity. It arises in 2 or 3 of the authorities. So you read all the material to establish the objective meaning. Which includes the explanatory notes. And your lordships have my submission of that. G. Well, I will leave G. Invite your lordships to read the head note to G.
Yes.
And concentrate on the first issue, if your lordships have the time to deal with it. The first issue, Lord Stevens differs from the reasoning of the Court of Appeal on the basis that the child in that case had made, it was to be regarded objectively as having made an application for asylum, although they hadn't put in a piece of paper. That is based upon paragraph 2, Article 2 of the Procedures Directive, the definition of which I showed your lordships at the outset. So it is part of the ratio. The Secretary of State is has instructed Council to accept that the Procedures Directive remains part of retained EU law. And until this litigation, there's not a hint of any view to the contrary. Now, I've trespassed on my time already. Thanks for the moment on my submissions.
Well, thank you very much, Mr. Drabble. Well, Lord Pennick, you've been sitting patiently for 2.5 days.
Thank you, my lords. It's been a pleasure. The case for the Secretary of State is that the 2020 Act is unambiguous in 4 respects. The first respect, I think, is not in dispute, and that is that the 2020 Act is not confined to removing retained EU law concerning free movement. That's what the long title says. End rights to free movement. Could I invite your lordships to go back to the text in the separate bundle? Your lordships have seen the long title, to end rights to free movement and to repeal other retained EU law relating to immigration. And that is confirmed by Section 1. Section 1 tells us that Schedule 1 makes provision to A,
end rights to free movement, and B, end other EU-derived rights and repeal other retained EU law relating to immigration. And other can mean only other than rights to free movement. That's the first respect in which this Act is, we say, unambiguous. The second respect in which the Act is unambiguous is that Parliament has specified what it means by, quote, other retained EU law relating to immigration. It has specified, as my Lord Briggs put to my friend a few moments ago, it has specified that by the opening words of Section 1, Schedule 1 makes provision to, and it's B that matters. So Parliament has told us that it is to Schedule 1 that one looks to identify what provision has been made by Parliament to end other EU-derived rights and repeal other retained EU law relating to immigration. The third respect in which the Act is unambiguous in my submission is that when we go to Schedule 1, paragraph 6, we see that Parliament has explained in very broad terms indeed the scope of, quote, relating to immigration. And it's important to return to what Parliament has actually said. And there are two provisions, 6.1a and 6.1b. Either will do for my purpose. 6.1a excludes from domestic law all EU-derived rights so far as they are A, inconsistent with or are otherwise capable of affecting, very broad term, either the interpretation or the application or the operation of any provision, I stress any, made by or, and I quote, I emphasise under, made by or under the Immigration Acts. Now that is a very, very broad statement of scope. And that's the relevant provision. And then B, or they are otherwise capable of affecting the exercise of functions in connection with immigration. So that's the third respect in which this Act is unambiguous. It's adopted a very broad statement of the scope of relating to immigration. And the fourth respect in which we say that the Act is unambiguous is we say it is plain beyond argument that the EU law provisions which purport to regulate asylum decisions fall within both 6.1a and 6.1b. The claimants are seeking to rely on the directive to impose obligations on the Secretary of State as to how she exercises the powers otherwise available to her to remove an asylum seeker to Rwanda. Now, there is no dispute that her powers under domestic law arise both under the immigration rules, rules 345A to D, and they arise under the Asylum and Immigration (brackets Treatment of Claimants) close brackets Act 2004, Schedule 3, paragraph 17. Now, the bulk of United Kingdom asylum law and procedure, as your lordships will know, is found in Part 11 of the immigration rules. And the immigration rules are made pursuant to the 1971 Immigration Act. It's section 3, subsection 2. Could I invite your lordships just to remind yourselves about what section 3.2 says? You find it at page 3816.
I don't think there's any dispute, is there, that the immigration rules are provisions made under the Immigration Act?
No, indeed. Absolutely not. But if one goes to page 3816, your lordships will see the breadth of the power. Section 3, subsection 2, the Secretary of State shall from time to time, and as soon as may be,
Sorry, Lord Penning, could you bear with me? I've got a problem getting the document.
3816, Immigration Act 1971. We're looking at section 3, which is headed Regulation of Entry into and Stay in the United Kingdom, and it's subsection 2. The Secretary of State shall from time to time, as soon as may be, lay before Parliament statements of the rules, or any changes in the rules, laid down by her as to the practice to be followed in the administration of this Act for regulating the entry into and the stay in the United Kingdom of persons required by this Act to have leave to enter. That's what immigration is all about, is regulating the entry into the United Kingdom and the stay in the United Kingdom of persons who require leave to enter, as of course asylum claimants do require leave to enter because they're not British nationals. And the legal position was accurately summarised by Lord Justice Underhill at paragraph 350 of his judgment. It's at page 575 of the bundle. He sets out at paragraph 350 what I've just read, section 3.2, and he says the immigration rules are made pursuant to that provision. Although their precise legal status is notoriously anomalous, it is not in issue before us, as my Lord Reid put to me, that for the purposes of paragraph 6.1, they are to be regarded as made under the Act. Part 11 of the rules regulates applications for asylum. Paragraphs 3, 4, 5, A to D fall under that part. So the immigration rules, which allow for removal to a safe third country, whether or not there is any prior connection with that country, are made pursuant to the Immigration Act. They regulate the circumstances in which the Secretary of State will exercise her statutory power to grant or refuse leave to enter and remain. And the connection between the asylum decision and leave to enter is not merely that the decision is made under the immigration rules. The immigration rules expressly state that a grant of refugee status results in a grant of limited leave to remain. Rules 330 and 335. The position is even clearer because, as your lordships have already seen, the term immigration acts is defined in section 61 of the UK Borders Act. And the list, we've seen it, was set out in Lord Justice Underhill's judgment at paragraph 349. And the list of what is covered by the term immigration acts includes a number of acts which do regulate asylum, not least the Immigration Act 1971 and the 2004 Act, Schedule 3 of which confers powers to remove to safe third countries. And the 2020 Act, as your lordships have seen, specifically refers to the 2007 Act interpretation of the term Immigration Act, see Section 4. So bringing this all together, we say if one returns to the language of the 2020 Act, Schedule 1, paragraph 6.1a, it is plain beyond argument that the EU-derived rights upon which my friend relies are, to put it at its lowest, capable of affecting the operation or application or operation of any provision made by or under the Immigration Acts. How could it be otherwise? The claimant's case is that the provisions of the Procedures Directive prevent, if they are applicable, prevent the Home Secretary from removing these claimants or any others to Rwanda because they don't have a prior connection with Rwanda. My Lords, I emphasise my case is not, as Mr. Drabble suggested, based on the word etc. That's not my case. My case is based on Parliament's detailed, broad explanation in paragraph 6.1a, and I'm coming to 6.1b, broad detailed explanation of what Parliament, considers is covered by the provisions of this Act relating to immigration. This is not, I submit, legislation, or rather the application of legislation by a, quote, sidewind. My Lord, Lord Sales put to my friend, and I respectfully agree with the sentiment, this is the express statement by Parliament as to what it intends the Act to cover. I also respectfully submit that it is a striking feature of my friend's argument that he makes, indeed he can make, no argument, no attempt to answer how the words that Parliament has chosen to enact in paragraph 6.1a could possibly be consistent with his case. His argument depends, it has to depend, on seeking to persuade the court to ignore what Parliament has enacted on the basis that the words should be substituted by an attempt to identify a narrow purpose of the legislation, even though the purpose of the legislation includes to exclude retained EU law relating to immigration, which is then defined. My Lords, we add, if there were any doubt about the application of paragraph 6.1a, we also rely on the very broad terms of 6.1b. Are these EU rights, quote, otherwise capable of affecting the exercise of functions in connection with immigration? And to make sense of this Act, one must construe the term immigration as extending to what is within the scope of the Immigration Acts, which is the subject of 6.1a. And we say that 6.1b plainly applies. It clearly covers the EU-derived rights on which reliance is placed, because those rights are said to confine or prevent a decision by the Secretary of State not to consider the merits of an asylum claim by which a person claims an entitlement to enter and remain in the United Kingdom, that being a central function of immigration, but instead to remove that person to another country. Whether to consider an asylum claim or whether to remove that person to a safe third country is, I say, plainly affecting the exercise of functions in connection with immigration. These are decisions on whether to remove from the United Kingdom persons who have no other legal basis to remain. I say with great respect, it is fanciful to suggest that an EU law provision which would, says Mr. Drabble, prevent the Home Secretary from removing to a third country a person with no other right to remain here is not a provision, quote, capable of affecting the exercise of functions in connection with immigration. Those, we say, are the unambiguous terms and effects of this legislation. I would respectfully add that it is very far from surprising that Parliament decided in this legislation to define, as it did in paragraph 6(1)(a) and (b), the concept of, quote, relating to immigration, unquote, in these broad terms. It is very far from surprising that in implementing Brexit, because of course this Act was designed and did come into effect at the end of the implementation period on the 31st of December 2020, Parliament decided in broad terms to remove previous powers of Brussels to regulate decision-making of the Secretary of State in applying the Immigration Acts and rules and in exercising immigration functions. That was, for good or for bad, one of the primary objectives of Brexit, to restore the powers of Parliament to decide on the control of our borders. That's our case on what this Act actually says and what it actually means. I say it is unambiguous. Mr. Drabble's response was, first of all, with respect, to ignore what Parliament has said in paragraph 6(1) and to ignore that section 1 directs attention to schedule 1, and I've dealt with that. Mr. Drabble then says that in domestic law usage there is a clear distinction between immigration and asylum. That would, in my respectful submission, not assist Mr. Drabble, even if it were true. In the context of the 2020 Act, Parliament has defined what it means by provisions relating to immigration. And it's a special context because the purpose is to implement Brexit and to restore powers of Parliament and to remove the powers of Brussels. But in any event, my friend's suggestion that in domestic law usage, immigration is distinct from asylum is, with respect, unsustainable. And Lord Justice Underhill dealt with that submission by Mr. Drabble at paragraph 361 of the Court of Appeal judgment. The Lordships will find it at page 578. Paragraph 361. I appreciate your lordships have read this already, but picking it up in the third line, his lordship says that Mr. Drabble is right that in some legislative contexts, immigration and asylum are treated as distinct subject matters. But his lordship's not persuaded there is any settled practice. There are instances in the legislative context of the term immigration being used to cover both immigration in the narrower sense and asylum. One example is the 2016 Act, although Mr. Drabble relies on the fact the long title refers to both asylum and immigration. It's also significant the short title does not. Equally, the immigration rules include the entirety of our rules governing the determination of asylum claims and are, of course, made under the Immigration Act 1971. And his lordship also points out that MacDonald's immigration law and practice, the Bible for practitioners, covers asylum law as part of immigration. That broader use is not loose or illogical. The effect of a grant of asylum is to confer on the beneficiary the right to remain in the UK, notwithstanding they do not have British nationality or other right of abode, and the relevant law can perfectly naturally be regarded as an aspect of immigration law. So there's nothing surprising or unusual about the usage of the language here. I emphasise, I'm not seeking to establish a consistent usage, because I say that what matters is the usage in this Act. And the usage in this Act is controlled by paragraph 6.1 of the schedule, which is unambiguous. My friend then emphasises that if one looks at EU law, there is a distinction between provisions which address immigration and provisions which address asylum. To which the answer is that in the 2020 Act with which we are concerned, Parliament has adopted its own definition of relating to immigration. Paragraphs 6.1a and b define the excluded EU law provisions not by reference to their status or labelling in EU law. On the contrary, Parliament defines what is excluded by reference to whether they are capable of affecting United Kingdom immigration provisions or functions. The point was made by my Lord Sale. So how a provision is defined or labelled in EU law is simply not the issue. My friend then took the court to the regulations made under Section 8 of the EU Withdrawal Act 2018. And can I take your lordships back, please, to the relevant provision? It starts in the bundle at page 3883. And I take your lordships to that page because that is the power, the statutory power, to make the regulations. And your lordships may recall when the 2018 Act was enacted, Section 4 created the concept of retained EU law, and Section 8, which is on page 3883, gave a minister power by regulations to make such provision as the minister considers appropriate to prevent, remedy or mitigate any failure of retained EU law to operate effectively, or B, any other deficiency in retained EU law arising from the withdrawal of the UK from the EU. So that was the statutory power. That was the power under which the regulations upon which my friend relies were made. It was a narrow function, essentially to remove from EU law regulations which were no longer relevant because the UK was no longer operating within EU systems. So, for example,
are you referring to the 2019 regulation?
Yes.
Yes. Thank you.
Yes. So it was dealing with things like the Dublin Convention and many others as well. And if we go then to the regulations, Mr. Drabble took the court to them. The relevant part is at 3887. And as your lordships can see on 3887 through to 3889, what these regulations did was to revoke a number of specific EU provisions. Part 1 on 3887 was under the heading, as Mr. Drabble emphasises, and is entitled to emphasise, revocations related to immigration and nationality, and there's a whole list of them. And on 3889, there were listed a number of specific provisions under the heading revocations related to asylum, one of them being H on that page, Dublin Convention. And Mr. Drabble's point is that this regulation distinguishes between revocations related to immigration on the one hand and revocations related to asylum on the other hand. Now, the 2019 regulations found it convenient to identify specific EU provisions in the field of immigration and specific EU provisions in the field of asylum, and it revoked them. I say that does not assist in the interpretation of the 2020 Act because it adopted a different approach. The 2020 Act, as the court has seen, did not list specific provisions of EU law which were to be excluded from retained EU law. Rather, paragraph 6 of Schedule 1 to the 2020 Act defined EU law provisions that were to be excluded from retained EU law by reference to their characteristics. That is, whether they were capable of affecting the application of any operation, of any provision made by or under the Immigration Act, or otherwise capable of affecting the exercise of functions in connection with immigration. That's paragraph 6.1a and 6.1b. A fundamentally different approach to that adopted in the 2019 regulations, which listed specific provisions of EU law. And that may well have been because of the specific and limited purpose of the power that I've shown the court in Section 8 of the 2018 Act. Now, I say the 2020 Act, paragraph 6 in particular, had a distinct function set out in the Act of removing from domestic law other immigration provisions as defined in paragraph 6.1. I do not accept that the 2019 regulations could assist the interpretation of the 2020 Act, far less when the 2020 Act is, I say, unambiguous in for the reasons I have given. Can I add, and it may not be necessary to address this point in any detail, but I do not accept, in principle, that regulations made under the 2018 Act can be an aid to construction of the 2020 Act. There is, of course, authority for the proposition that regulations that are made contemporaneously with the legislation under which they are made can be an aid to the interpretation of that legislation. My Lord Sales dealt with that issue in the Packard judgment, paragraphs 44 to 45. It's at page 7031 of the bundle, 7031. But of course, the 2019 regulations were made under different legislation, the 2018 Act. They were not contemporaneous with the 2020 Act, and they served a different function. I can find no authority for the proposition that regulations made under another Act, an earlier Act, assist on the proper interpretation of a later Act. And indeed, there may be constitutional concerns if regulations made by the executive under earlier legislation can affect the meaning of what Parliament has said on a later occasion, particularly if it's said that they supplant the language used in the later Act. So that's what I say on the 2019.
May they not help to identify the legal territory onto which a new piece of legislation is to be grafted, and therefore be of some assistance in
Depends on the context, but I accept. Yes, they may.
I just wonder if you're not putting your submission in slightly stark terms.
Yes, but I don't want to invite the court to rule out the possibility. I prefer to take my stand on the proposition that the earlier regulations were made under a statutory power with a specific purpose, and what they can't do in any event is to supplant, if I'm right, what is an unambiguous provision of a later Act. I prefer to put my submissions in that way. Now, my Lords, none of this is to dispute in any way that the language of a statute must be read and understood in its statutory context. That's not a proposition, of course, that I dispute. And my Lord Hodge addressed the topic, the court's very, very familiar with it, the topic of the statutory context in the project for the registration of children as British citizens, which paragraphs 28 to 30, I won't take the court to it, page 6985. But I do emphasise that my Lord said for the court, and I respectfully adopt paragraph 29, that, and I quote, "The courts in conducting statutory interpretation are seeking the meaning of the words which Parliament used," unquote. My Lord emphasised that the words must be read in the context of the relevant group of sections and other provisions in the statute. And I've made my submissions on that. I'm not seeking to isolate paragraph 6.1 of the schedule out of context. I'm inviting the court to interpret it in the context of the long title and section 1, which directs attention to schedule 1. But my Lord Hodge emphasised in that paragraph 29, that they are the words which Parliament has chosen to enact as an expression of the purpose of the legislation, and they are therefore the primary source by which meaning is ascertained. And my Lord Hodge added, and I respectfully adopt, that there is an important constitutional reason for having regard primarily to the statutory language in its statutory context. And my Lord referred to the words of Lord Nichols in an earlier case. People should be able to rely upon what they read in an Act of Parliament. And that's an important constitutional purpose. I say here, the words of the statute are very clear, they're very broad, and it's not difficult to understand why they were enacted in such broad terms. Lord Justice Underhill addressed the question at paragraph 362 and 363. It's at the bottom of 578. At 362, bottom of 578, his lordship said, if the use of the term immigration itself does not clearly connote an asylum exclusive purpose, and I've made my submissions on that, I see nothing else in the statute that does so. The fact that the primary purpose is to end free movement is, in his lordship's view, neutral. It does not follow that the, quote, other EU-derived rights relating to immigration law need to be in some sense akin to free movement rights or otherwise relate to immigration in the narrow sense. The only overall purpose that can be discerned is to remove or qualify EU-derived rights which are inconsistent with domestic immigration legislation, including the immigration rules. There is no a priori reason why the rights in question should not relate to asylum. The upshot is there's nothing in the other provisions of the Act to suggest a legislative purpose that would justify departing from the literal language of paragraph 6.1, and we respectfully agree. My friend suggested that the reference to rights relating to immigration may be intended to refer to matters such as derivative rights for primary carers of EU citizen children, matters of that sort. Well, if Parliament had been only concerned with such matters, it is, with respect, quite impossible to understand why paragraph 6.1a and b was drafted in the terms that the court sees. My friend then relied on external aids to interpretation. Again, my Lord Hodge for the court dealt with the relevance of external aids in the project for the registration of children case, paragraph 30. It's page 6985. My Lord emphasised.
It's 7001. 6985 is the opening of the case.
Ah, right. It's paragraph 30.
7001.
Thank you, my Lord. Yes. And I hope I accurately paraphrase paragraph 30. Your Lordship said that external aids to interpretation must play a secondary role. They can be relevant to assist the court to ascertain the meaning of the statute, whether or not there's ambiguity and uncertainty, and indeed may reveal ambiguity or uncertainty. But, and this is what your Lordship added, but none of these external aids displace the meanings conveyed by the words of a statute that, after consideration of that context, are clear and unambiguous and do not produce absurdity. I respectfully add that any other approach would frustrate the constitutional objective stated by Lord Nichols, approved by my Lord for the court at the end of paragraph 29, that citizens must be able to read and rely on what Parliament has enacted. My submission is that none of the external aids on which my friend relies come close to displacing the clear and unambiguous meaning of the words contained in the Act, read in their statutory context. I respectfully submit that external aids do not permit the court to replace the language of the 2020 Act read in its statutory context. Far less do they permit, as Mr. Drabble is seeking, the whole-scale negation of paragraph 6.1a, on which my friend has no submission at all as to its language, other than to seek to remove it by reference to what he says is a narrow statutory purpose in section 1. Nor is the interpretation for which we contend close to absurdity, for the reason that I gave. It is very far from absurd for Parliament in the 2020 Act, in a statute implementing Brexit, to take the approach that we say it did take. In any event, we do not accept that the external aids assist my friend's case. He relies on the explanatory notes. Could I please take your lordships back to the explanatory notes and pick it up at page 8098. This is the opening page of the explanatory notes, and your lordships see the heading, "What these notes do," and the final bullet point is a cautionary note. These explanatory notes might best be read alongside the bill. They are not, and are not intended to be, a comprehensive description of the bill. And I respectfully emphasise that point. And therefore, an argument made by my friend as to what the notes do not say in relation to the scope of a particular clause is of very limited weight.
Yes, the first sentence of the first two sentences of the first bullet point are significant also.
Yes, they are, my lord. These notes have been prepared in order to assist the reader. They do not form part of the bill, and they've not been endorsed by Parliament. Indeed so.
Is it simply the Home Office's take on the bill?
Indeed. Indeed. And as your lordship put to my friend, the intentions of the Home Office are no doubt fascinating, but they do not govern the proper interpretation of the legislation as enacted. Paragraph 28 was referred to. Was it? No. Can I invite your lordship's attention to 8106? Paragraph 28 is dealing with Clause 1. It's the explanation of Clause 1. This clause introduces Schedule 1, which repeals legislation relating to free movement and other EU law relating to immigration. Indeed, it does. And that confirms, if confirmation is needed, that Section 1 looks to Schedule 1, as my Lord Briggs suggested to my friend, as the definition of what is meant by relating to immigration. My friend drew attention to paragraph 68, which is on page 8110, and your lordships put to my friend comments, my Lord Sales, I think it was, put to my friend the first sentence of paragraph 68 is entirely consistent with the findings of the Court of Appeal and our submission, and I won't labour the point. And my Lord put to my friend that the list on 8111 is not particularly helpful, given that it's a non-exhaustive list. So I don't accept, with respect, that the explanatory notes take this matter further forward in relation to this case. My friend mentioned the importance of the rights that are protected by the Procedures Directive. But of course, in relation to this case and the conflict between the Procedures Directive and the immigration rules, which is the only conflict that attention has been directed towards. No one has identified any other conflicts. The claim by the claimants that it is a breach of international law to send them as asylum seekers to a third country with which they have no prior connection was, as my Lord Sales indicated, a claim that was rejected by the Court of Appeal. For your Lordship's note, the Court of Appeal dealt with this matter at paragraphs 309 through to 319, in particular at paragraph 319, rejecting my friend Mr. Drabble's argument that the Refugee Convention requires the criteria in Article 27 of the Procedures Directive to be applied. And there's no appeal to this court on that matter. My friend refers in his written argument to the legality principle. He's not had time to address that today. We've answered it in our written case, if your Lordships are interested in that. We say legality. The legality principle doesn't assist here, both for the reason I've just given, that we're not concerned with a fundamental right in relation to removal to a safe third country, and also because the principle of legality cannot assist in this case, where the express purpose of the 2020 Act is to remove parts of retained EU law, including, we all agree, the free movement of persons, which is one of the four fundamental freedoms of EU law. Such an act should be construed fairly in accordance with its terms. And I've made my submissions on why it's unambiguous. Finally, my friend relied today on two judgments of this court. The first was G and G, where my Lord Stevens for the court noted that the Secretary of State had accepted for the purpose, it's paragraph 84 on page 6774 for your Lordship's note, the Secretary of State had accepted that the relevant provisions of the directive remain part of domestic law as retained EU law after the UK's withdrawal from the EU. As your Lordships have heard, there was no argument on that issue in that case. There was no mention of the 2020 Act, far less its terms, either in the judgment or in the arguments, which are fully reported in the law report commencing at 6738 of the bundle. And all of that is acknowledged by my friend in his written case. Paragraph 40, he acknowledges, therefore, G and G cannot be binding on this court in the present case. I respectfully submit that a comment by Lord Stevens on an issue not argued, where there's no reference to the 2020 Act, cannot provide any assistance to your Lordships. We've referred in our written case, it's paragraph 141, to the authorities that even a lower court is not bound to follow a Supreme Court judgment on a point which was not argued. Given the authority, it's Lord Justice Leggett, as he then was, for the Court of Appeal. It's in paragraph 141 of our written case, but it's not in dispute between us. Mr. Drabble's argument is that, well, Lord Stevens knew about the 2020 Act because he'd heard argument in an earlier case of Robinson, which is at 6920. And all that Lord Stevens said in that case it was paragraph 29 at page 6940, was that the 2020 Act, quote, provides for repeal of the main retained EU law relating to free movement, unquote. Well, so it did. But that's not all that it did, as is plain from the contrast between section 6.1a and 6.1b, and as is plain from Schedule 1. The Robinson case was only concerned with free movement. It wasn't concerned with any other matter. And therefore, it doesn't advance the argument for my friend to refer to that case. I hope that addresses, on behalf of the Secretary of State, at least the main arguments that your lordships have heard from Mr. Drabble today. I'm very happy, of course, to seek to address any other points that I've omitted, but subject to that, that's what I want to say on behalf of the Home Secretary. Thank you.
Thank you very much, Lord Bannock. Mr. Drabble?
Yep. My Lord, can I start the reply, which will be short, by referring back to the question that Lord Briggs put to me about the relationship between the enacting provision in the main corpus of a statute and the schedule. Because it's the choice between the approach to that issue in the context of this particular statute that, in my submission, drives the answer to the case. I fully accept that there will be statutes in which the words in the main body of the enactment that introduce the schedule are brief, and where the content of the schedule is to be derived from the language used in the schedule itself. But equally, as I think was implicit in the way in which Lord Briggs put the point to me, but in any event I submit is correct, there will be statutes in which the purpose of the schedule is spelled out in the main enacting provisions, in which case one would approach the wording of the schedule on the basis of what has been said in the earlier provision which enacted it. The choice between the two must be a question of context. And in this case, as in so many things, context is everything. The question is whether it is appropriate to approach Schedule 1, and in particular paragraph 6, as driving the content of Section 1, so that effectively paragraph 6, and I think this is my Lord Pannick's point, Schedule 1 functions as a definition section to the meaning of the words relating to immigration that we find in Section 1 itself. In my submission, that is the wrong way round when one has looked at all the material, which is admissible material, in the light of the statutory authorities, or the authorities on statutory interpretation. So in our respectful submission, what one finds in Section 1 is a detailed piece of drafting which has to be read in the light of all the material contained in the enactment, which includes the long title, and which includes the heading to Part 1, in which both Section 1 and paragraph 6 are to be found.
I mean, if I may say so, it didn't seem to me that it was primarily an argument by reference to purpose that Lord Pannick was presenting. He's saying that it's also important, as it is important in this case, what concepts are used in Section 1. And in Section 1b, you have a very unspecific, open-ended concept, other EU-derived rights.
Yes.
The section doesn't tell you what those are, but
Well,
it points to, well, just to finish the point,
of course,
it points you on to another place in the statute which does tell you what.
well, I completely understand that is Lord Panic's perspective. Our perspective is you start with section 1, you look at the heading to part 1, because that tells you the context in which you construe section 1, so that when you approach the wording of section 1, you know that you are dealing with measures relating to ending free movement, because the heading to the whole part says so. You know, when you get into the wording of section 1 itself, that you're dealing with the repeal of main retained EU law relating to free movement, etc. And so the question is whether what your lordship has just put to me, which is there's an ill-defined concept about relating to immigration in the fallout words of 1B, is actually a fair description of what is said in 1B, because I don't accept that. What is said in 1B is that Schedule 1 makes provision to ending free movement, correct. Every provision of section of the part does relate to the ending of free movement, apart from the disputed words in section 6. Sorry, paragraph 6. You then ask yourself, is that widened in this statute, not with a theoretical relationship between the section and the schedule, but this statute, what is the relationship between the enacting provision in section 1, enacting provision is the right word for the provision in the main body of the statute, and the schedule? Or you know you're going to be going to the schedule to find provisions that are dealing with the repeal of the main retained EU law relating to free movement, because that's been said, I think, 3 times in the admissible provisions in the long title, the heading to part 1 and the heading to section 1. So in my submission, it's just not correct to say that one approaches paragraph 6 on the basis that it drives backwards and tells you what section 1 is about. The correct approach to this provision, this section, or this statute rather, is to treat it as one in which section 1 does define the scope of the schedule. It tells you in limbs A and B what the section is designed to deal with. And you come back to the merits point. If that is not right, then the conclusion is that the wide wording of the opening words of paragraph 6 are unconstrained by anything in the heading to part 1 of the Act itself, or to the heading of section 1, but simply, without any introduction, already sought by the executive or, on the face of it, by Parliament, about the effect of that wide wording. Now, at the end of the day, your lordships have to make a choice as to what the right relationship is between section 1 and the schedule. I fully accept that it's conceptually possible, indeed possibly normal, as the Lord Briggs was putting to me, to find very short introductory words in the enacting provision in the main provisions, and detailed provision made in the schedule which do drive the meaning and content of the schedule. This is just not such a case, because we know, we're told repeatedly by admissible provisions, in i.e. the long title, the heading to part 1 and the heading to section 1, that we are dealing with a primary focus of the ending of free movement. And so, task for the court and the authorities that I'm just going to go back to in a moment is to ascertain what the objective meaning of these 2 provisions read in context is.
If it doesn't do that, then we do get my Sidewind point. I mean, it is the point that without anyone having addressed the issue about do we intend to remove the corpus of asylum law from retained EU law, it's done by accident and without anyone thinking about it. It was precisely what Lord Justice Underhill held, and it's correct. So you have a choice. And my submission is the answer is to ascertain the objective meaning of the provisions made as a whole. Now, if we go into that mix, one puts the explanatory notes. I don't accept that one can relegate to unimportance the fact that the explanatory notes do refer to a series of directives which the relevant responsible department, the Home Office, thought they were dealing with, but do not include any of the directives relating to asylum law. Lord Justice Underhill, in the passage which we've already seen, did accept that it was unlikely that the Secretary of State had given his mind to the wider consequences of paragraph 6. The obvious target is precisely what the notes tell you the target is. So my submission is one can't dismiss my case on the basis that the clear wording of paragraph 6 drives the answer if you accept that if you go back to 1b, section 1b, words relating to immigration, read in the context just of the statute at the moment, do refer to the narrow concept of immigration and not asylum. Once you accept that, then paragraph 6 falls into place and doesn't drive backwards as a definition. I mean, I think it is being used as a definition section, actually, of the concept of relating to immigration in section 1. The question is that a realistic way of looking at this statute? And in my submission, the answer is no. Now, in my submission, all of that, including the reference to the explanatory notes, fits straightforwardly into the main authorities, which I didn't take your lordships to before in opening. But if I can just use them as an agenda, I don't know more than that for 5 minutes worth of just seeing how I put my case. Your lordships will look first of all at NAS, the case on explanatory notes. Page 6908, I'm very grateful.
Page?
6908.
Thank you.
This is quite an old case, and from memory, Lord Steyn talks about explanatory notes, but none of the other members of the appellate committee agree with him. The reason I raise that is one might think that in light of the Britsitz judgment in particular, which deals with explanatory notes recently and in the way that the whole court deals with, that it would be Britsitz which would be the more useful authority.
Well,
I don't want to stop you going to it.
I'm going to.
There are problems with NAS, which are long-standing and well-known.
Yes, well, I'm going to NAS. Your Lordship is, of course, right. The Lord Steyn starts off by saying what I'm about to say doesn't affect the outcome because I agree I agree with the result of the reasoning of the majority.
But nonetheless, the other way round, the majority don't agree with these comments, so their state.
Well, they don't disagree with them, as I understand it. I'm sure that's right. I mean, this found its way into the judgment, as I understand it, because Lord Steyn had prepared an explanation of the role of the explanatory notes following the adoption of the new system, which he describes in paragraph 4 at 6908.
And despite the conclusion on the issue in the case being unaffected by the reference to this passage on explanatory notes, it stayed in the judgment, and presumably, I anticipate, after some discussion of its continued relevance. But paragraph 4 sets out what was then the new system. Paragraph 5 says the question was whether in aid of an interpretation of a statute the court may take into account the explanatory notes, and if so, to what extent. The starting point is that language in all legal text conveys meaning according to the circumstances in which it was used. It follows that the context must always be identified and considered before the process of construction or during it. It's therefore wrong to say the court may only resort to evidence of the contextual scene where an ambiguity has arisen. In regard to contractual interpretation, this was made clear by Lord Wilberforce, and there's a reference to contract cases. And just above letter H, the same applies to statutory construction. In River Weir, Commissioners and Adamson, Lord Blackburn explained the position as follows. And that quote is set out, and then back in the judgment of Lord Steyn, again, there is no need to establish an ambiguity before taking into account the objective circumstances to which the language relates. Applied to the subject under consideration, the result is as follows. So far as the explanatory notes cast light on the objective setting or contextual scene of the statute and the mischief at which it is aimed, such materials are therefore always admissible aids to construction. They may be admitted for what logical value they have. Used for this purpose, the explanatory notes will sometimes be more informative and more valuable than other materials, such as the Law Commission. Now, pausing there, we know from material which is part of the enactment, namely the headings and the long title, that the primary purpose, as Lord Justice Underhill accepts, of this statute is the ending of the right to free movement. We know from the explanatory notes that the sponsoring department did not think that the main asylum directives were being affected by the provisions that were being enacted, in particular by the opening words of paragraph 6 of Schedule 1. Carrying out the principal task of the court, which is to ascertain the objective meaning of the words used in the enactment, we say that you give primacy to the construction of Section 1 in that context, and that it is not driven, as it might in other contexts be, by a provision in the schedule. We approach paragraph 6 on the basis that it's axiomatic that it's dealing with other rights related to immigration, at the worst from my point of view. Immigration in that context meaning immigration in the narrow sense explained by Lord Justice Underhill. That just is what Parliament thought it was doing. See the explanatory notes and see the titles.
Well, it's not what Parliament thought it was doing. We assess what Parliament thinks it was doing by an objective interpretation of the words used.
I completely agree.
And with respect, aren't you trying to use the explanatory notes to, I don't know what a fair word is, to do some violence to the statutory words? Because what the Home Office may have thought really is neither here nor there.
Well, it's not neither here nor there. All the authorities on explanatory notes do not say that. Including your lordship in O. I'll come to that in a moment.
It is a secondary. It is a secondary measure in the hierarchy of the process of statutory interpretation, and cannot be used against unambiguous words.
If they are unambiguous, going back to my way of approaching this issue, the question is what is meant by unambiguous words.
But what you're trying to do is use the explanatory notes to give primacy to section 1.
It's not. Sorry,
Well, that's my understanding of what you've just been saying to me.
No. We do what your lordship tells us to do in O. You look at all the material before deciding on what the correct construction is. It may be that the literal meaning of the words must prevail because the explanatory notes are secondary, but we have here a whole corpus of material to refer to. 1, the long title. 2, the heading to part 1, and it just has the point. I say there's a plain, the very worst from my point of view, ambiguity about the relationship between section 1 and paragraph 6 before you come near the explanatory notes. So what is being held against me, what Lord Panic is saying, is I can't get, you Mr. Drabble, can't get out of the clear wording of paragraph 6, indeed you're not even trying to. Whereas I say that is because before you get to paragraph 6 on this statute, you know you're not dealing with, you know the schedule is dealing with free movement, that's not this case, and you know it's dealing with other rights relating to immigration. We'll come to, just in the light of the titles, that doesn't include asylum, put beyond doubt by the explanatory notes. That's the way around I wish to put it. Yep. And if I can carry out my implied threat or otherwise to go to the citizenship case, paragraph 30, your lordship's judgment.
Sorry, page?
7001.
Yes, the authority starts at 6985 and paragraph 30, as we've just established, is at 7001. Well, actually, paragraph 29. And picking it up under the reference to Spat Home, 1/3 of the way through the paragraph, words and passages in a statute derive their meaning from their context. A phrase or passage must be read in the context of the section as a whole and in the wider context of a relevant group of sections. Other provisions in a statute and the statute as a whole may provide the relevant context. They are the words which Parliament has used. Now, just stopping there, the enactment contains the long title, the 2 headings, and the wordings for section 1. So stopping there, we have a detailed provision in section 1, which is the key to this case. And then there's a constitutional reason. The constitutional reason doesn't take us any further here because it's plain and accepted by Lord Justice Underhill that the reference to immigration in 1B can be a reference to the wide concept of immigration or the narrow one for which I contended. And the question is, the fundamental question is, what is the objective meaning of the 2 provisions, Section 1 and Schedule 1, read together?
I'd rather read Lord Justice Underhill as saying the natural meaning in an English law context of immigration is the wide meaning. That was paragraph 362, I think.
Yep. I mean,
yeah, 361.
well, I don't think he is saying that, actually. It's 361. He says it's not clear. And 362 does not clearly connote an asylum exclusive purpose. Now, as I said, I think...
But that's the negative point that follows from the first. I did rather read 361 as him saying, in an English context, the more natural meaning of immigration is the wide meaning. The question then is whether... in this context, immigration actually clearly connotes an asylum exclusive purpose. In other words, to cut back the natural meaning. And he says no.
I don't accept it. Just as a reading of paragraph 361, I don't accept that's what he's saying.
All right.
He is saying I'm going too far because I mean his description of my argument is that I'm saying that immigration can't include asylum. I'm not quite sure that was quite my argument. Let's not get too fussed about that. But he's not saying there is a natural meaning in which it includes asylum. It's it's not clear. That's what he says.
What he's saying is it's not clear that the word excludes asylum. That's what he's saying in line.
Yes, I know, and I don't understand why he's saying that. I mean, that's not the correct construction exercise. As your Lordship has said, you start by looking at all the provisions in order to ascertain the objective meaning of the provision in the case. You're not looking to see whether it's clear it excludes concept X or concept Y. You are just trying to see what the draft... Sorry, I was going to fall into the trap of saying what the draftsman had in mind. I mean, that isn't the question, as we've been discussing. What objectively the wording of Section 1, read in the light of the titles and in the light of the explanatory note, means. And we say, once you do that, you do get a narrow meaning to the word immigration. And then we come back to the relationship between Section 1 and paragraph 6, with which I started this reply. So I'm not disputing that you can find in a schedule precise words which drive the introductory section in the principal body of the Act. It's just that that is not this case. If it was this case, I mean, it's not this case, as is demonstrated by the Secretary of State's instructions to Council in GVG, the explanatory notes, the other cases, the other decisions we've referred to in our case, in none of which the Secretary of State said, we think that ICSA means that the Procedures Directive are not part of retained law. Just no one says it, because it wasn't. It wasn't what they were seeking to do. Now, there's one, can I just do one other thing, and then I think it probably will be 4 o'clock. There was some discussion about the list of long titles in our case. Or Justice Underhill has the point about short titles, the short title of, I think, the 2016 Act. If your Lordships, in the fullness of time, look at what we have said in paragraph 18, which is, your Lordships will find at page 386, every case in that list where there are specific provisions relating to asylum, the fact that the Act is dealing with asylum is referred to in the long title, in every one of them. Not true of the short title, as Lord Justice Underhill points out, but it is true of the long title. Just ask your Lordships to read what we said in paragraph 18.
Immigration Act 1960.
But I can only go back, I mean, that is the reply. And if the court does not accept that relationship between Section 1 and paragraph 6, in my respectful submission, the court will be producing a result which was not intended by the draftsman. I know that doesn't matter, because we're looking at the objective meaning of the words used, but it will be producing that result. There's no sign at all that the Secretary of State intended to revoke the Procedures Directive at any point before this litigation began. Those are my submissions.
Well, thank you very much, Mr. Draggle. We're all most grateful to all counsel and those who, the many people who no doubt have assisted them in presenting such a complex case to us as efficiently as you have done. Thank you very much. I appreciate that people will be anxious to know how long it's going to take us to produce a judgment. I'm afraid it's difficult to say. You can see how long the courts below took. We don't have quite as many issues, but on the other hand, we do have to hear other cases in the meantime. I'm hoping it will be a similar sort of time frame to the lower courts. The court will adjourn.